We often hear repeated a number of myths about copyright protection and infringement. These myths are legally inaccurate, and relying upon them could be an expensive mistake. Here are some of the most common. Number 1. You have to register your copyright to protect it. False. In the UK, copyright is an automatic right. This means that you do not need to formally register your rights in order to own them. Given the absence of a formal registration procedure, it's advisable that you create and maintain an ongoing record of the works that you create in order to try to prove the date of creation and your ownership. But bear in mind that copying can only occur if others have access to your works. If they've not been published, you may not be able to prove copying. Number 2. My ideas are protected by copyright. False. Copyright protects the expression of an idea in a fixed recorded format, but not the idea itself. Ideas and abstract concepts, systems and methods are not protected by copyright. If you're concerned about obtaining protection for the actual idea itself, for example, if it is an idea for a new invention, then you should seek the advice of a patent attorney as to whether it will be possible to obtain patent protection. Number 3. Making copies is allowed as long as you don't sell them or make any money. False. Copyright infringement arises if any copies are made without the consent of the copyright owner, irrespective of how the copies are subsequently used or if they are sold. Number 4. If you copy less than 10%, it doesn't amount to copyright infringement. False. Any unauthorized copying can amount to infringement. The only exceptions to this arise under the fair dealing provisions outlined in Chapter 3 of the Copyright Designs and Patents Act 1988. These permit a limited amount of use of a copyright work for certain purposes. For example, non-commercial research or private study, copies and lending by librarians or educational establishments to students, making a copy for a visually impaired person if no accessible version is commercially available, quoting for review or critique, or news reporting, with acknowledgement of the source. Incidental inclusion. This is where a copyright work is unintentionally included in a work, for example, in the background. Never assume that you'll be entitled to rely on the fair dealing provisions. Always seek advice as to your particular circumstances. Number 5. If I make some changes, it's not the same piece of work, and therefore not copyright infringement. False. Copyright is infringed by the act of either copying or adapting a work. An adapted copy is known as a derived work. Claiming authorship of a derived work could arguably also amount to infringement of moral rights. So the only safe option is either to get the copyright owner's permission or to create something entirely new and original yourself from scratch. Always seek professional advice about copyright matters. Mistakes can be costly. Thanks for listening.